I'm not going to hold your hand and babysit you and teach you the law. I'm advising you to speak to this attorney who does know.
I'm not taking this out.
It's clear to me that you don't know how to represent yourself because you can't answer the fundamental, simple, basic question of...
Welcome to Bench Report Court Cam.
Calling case number 25674 FY, People versus Tamara Lee Whitmer. Appearances.
Hello?
Hello. Your appearance to the record.
I'm sorry, Your Honor, I couldn't hear. Good afternoon, Your Honor. Nijad Mihana, appearing on behalf of Miss Whitmer, P59371.
Miss Whitmer, could you please state your name for the record?
It's Tamara Lee Whitmer.
Okay, and today is the date and time set for a probable cause conference. It's being conducted by Zoom. Do you give Zoom consent for this hearing on behalf of your client counsel?
Well, Judge, I suppose the first thing we should address is my client does not wish to have an attorney and she wants to represent herself.
All right. Ms. Whitmer, do you understand that you have the right to have an attorney present? If you cannot afford one, won't be appointed to represent you at public expense. Do you understand that?
Yes.
Knowing that, do you wish to waive your right to have an attorney?
Yes.
Do you also understand that when you represent yourself, that you are held to the same standard as an attorney, which means you are required to know the rules of evidence, the rules of procedure, you are to know how to conduct yourself in court, etc. Do you understand that you're still held to the same standard as an attorney?
Yes.
And you understand that even attorneys who have been through law school and been through college and have had numerous years of practice, that sometimes they encounter situations and legal issues that they have to research and question, etc. And knowing that they still have to do that, and you not being an attorney, you still want to represent yourself.
Yes.
You're positive.
Yes.
Okay. Counsel, would you mind just being on standby just to make sure I do everything right?
Yeah.
Thank you. All right. So today's the date and time set for a probable cause conference. It's being conducted by Zoom. Ms. Whitmer, do you agree to appear by Zoom?
Yes.
Okay. How do you wish to proceed?
Not guilty.
Okay. A not guilty plea has already been entered on your behalf. See, this is what I'm talking about. You're expected to know how to answer that question. So what do you wish to do today?
Tell my side of the story.
Okay. So that typically happens at a trial. So now, what would you like to do?
Take it to trial because I don't want to do 2 years.
Okay, but this is a felony case, so you can't just go right to trial. There's certain procedures in place that you have to decide whether or not you wish to move forward with. I'm not going to hold your hand and babysit you and teach you the law because I don't have time. So you want to represent yourself, so tell me what you would like to do. If you don't know, then I trust or I'm advising you to speak to this attorney who does know.
I'm not taking his help.
You can't talk at the same time. He can present you the options and then you can tell him what you want to do.
No, thank you.
Okay. Do you want to have a preliminary examination in this case?
Meaning?
Oh, this is a PCC. Okay. I'm not going to explain it to you. You don't know what an exam is? So how do you know if you want it or not?
I don't want an attorney.
Okay, but it's clear to me that you don't know how to represent yourself because you can't answer the fundamental, simple, basic question of how do you wish to proceed?
Right. I told you, I'm not pleading guilty to it.
Nobody's asking you to.
No one's mental. I'm not going to pay the state. I already have government. I already have corruption reporting.
Okay.
By law enforcement, by the way. I have harassment already reported. That's what
Okay.
this is over.
Here are your options. You can either have this matter set for a preliminary examination, or you can waive your preliminary examination, have this bound over to Third Circuit Court.
Mm,
Do you know what a preliminary examination is?
no.
A preliminary examination looks a lot like a trial. The prosecutor comes into the courtroom and he or she will call witnesses to the stand. You or your attorney will be given an opportunity to cross-examine or confront those witnesses. The only difference between a preliminary examination and a trial is that the prosecutor has a burden of proof of showing by a probable cause standard that there is a sufficient basis for the charges. Meaning, in other words, the prosecutor has to show that there was a crime that was probably committed in either Wyandotte or Riverview, and that you were the individual who probably committed it. That's all they have to show. The court will not consider defenses. It's just to make sure that there is a sufficient factual basis to allow this case to move forward to the next level of in the judicial system, which would be circuit court. Knowing that, do you wish to move forward with a preliminary examination, or do you wish to waive?
Waive.
Counsel? Is he there? I'm telling he left. Oh, there.
Right here, Judge.
I just had a heart attack.
The issue, Judge, is that I don't have discovery, and I think the prosecution was going to send it to me this morning. I don't know if I have it yet. And so I don't have the discovery to be able to assist her with what she would do, and she does not want to talk to me, so.
Well, I guess now I'm having concerns about competency.
Me too.
Any objection to just referring this for a competency review?
My only concern is I didn't get a chance to be able to flush that out from her. And
Why don't you, can you place on the record what your position would be? It sounds like she doesn't want to talk to you.
that's correct, Judge. So I wanted to explore with her the issue of competency referral and what it would entail and so forth, given the fact that she's locked up as well. But I couldn't do any of that. And when I tried to inquire, he wouldn't let me. And she denied that she has any issues and said, "Why are you asking me the questions? You're not my attorney."
Okay. Do you know if we need a stipulation from the prosecutor to obtain a competency referral? Can the court do it sua sponte?
I think the court can do it. Either party can ask for it, and including the judge can also send the referral if they think there is a need.
Court is going to refer this matter for a competency evaluation. Bond is continued. Do you usually set a competency hearing about 90 days out, Madam Court Reporter?
You should do a review about 3 months. So
Court will set a competency hearing. We'll bring us to August. Can I get a date in August? You have one right there?
yes, and August 28th.
Then would that be 9 a.m.?
We can do that.
All right. Let's set this for a competency hearing August 28th at 9 a.m. by Zoom.
Okay, sounds good, Your Honor.
Anything else for this record?
No, Your Honor, thank you.
Thank you. That will conclude this hearing.
Thanks for watching. Stick around longer and click the highlighted videos to your right. See you there.